Apple lost in court, then charged developers for losing. During discovery, Apple engineers flagged that a proposed App Store policy change would significantly reduce developer choice. That language was edited out before the document reached leadership. Who made that call has never been publicly named. Developers paid Apple $99 billion in commissions between 2016 and 2021. Apple disclosed that number themselves. There is one door into the iPhone. Apple holds the key. There has never been a second door. Tim Cook called the App Store a feature of the iPhone in 2020. What he didn't say, that feature generates an estimated $85 billion per year, more than McDonald's entire global operation. Apple's own financial witness during the Epic trial acknowledged the App Store's operating margin likely exceeded 75%. A 75% margin on a mandatory platform is not a service fee. It is a toll. Internal records from the Epic Games versus Apple federal litigation show Apple's leadership modeled what a commission cut would cost them, reducing to 20% across the board, approximately $4 billion per year in lost revenue. They ran the numbers. They chose the number they had. It gets worse. A federal judge later described Apple's court-ordered compliance as a calculated move to undermine the injunction and referred the matter for criminal contempt investigation. The Epic Games lawsuit cracked something open. In August 2020, Epic, maker of Fortnite, deliberately embedded a direct payment option inside its iOS app, bypassing Apple's billing system. Apple removed Fortnite from the App Store within hours. Epic had planned for this. They filed a lawsuit the same day. What followed was 2 years of discovery. Depositions, internal emails, financial models. Apple had never intended to release. One document showed Apple's own analysis estimating that reducing its commission to 20% across the board would cost the company approximately $4 billion per year. They had modeled the cut. They had chosen not to take it. Apple's public defense rested on 2 pillars. First, the 30% commission is industry standard. Google charges the same. Second, the App Store's costs, security review, infrastructure, fraud prevention, justify the fee. Both claims were challenged under oath. Apple's own financial witness during the Epic trial acknowledged that the App Store's operating margin likely exceeded 75%. Testimony suggested internal figures placed it higher. A 75% margin on a mandatory platform is not a service fee. It is a toll. David Heinemeier Hansson built a product called Hey, an email app. In 2020, he tried to list it on the App Store. Apple rejected it. Not for security reasons. Not for content violations. Because Hey charged users directly through its own website and offered no in-app purchase option for Apple to collect on. Hansson testified before the Senate Judiciary Committee. He said Apple's review process felt less like a quality gate and more like, his words, a shakedown. He is not a fringe figure. He is the creator of Ruby on Rails, one of the most widely used web frameworks in existence. He has built software for decades. Apple's response to his Senate testimony, no comment. The federal case produced a ruling in 2021. Judge Yvonne Gonzalez-Rogers found that Apple held anti-competitive conduct in the market for iOS app distribution. But she stopped short of calling it a monopoly under federal antitrust law. Apple declared victory. Their stock moved up. What the headlines missed, the judge also issued an injunction ordering Apple to allow developers to include external payment links inside their apps. Apple appealed. The appeal ran for 2 years. When the injunction finally went into effect in 2024, after the Supreme Court declined to block it, Apple's implementation looked like this. Developers could add an external link, but Apple would still collect a 27% commission on any purchase made through it. A link to your own website, still taxed by Apple. Apple's response to losing the anti-steering case, charged 27% for the privilege of linking out. Here is where it gets stranger. Apple's compliance filing with the court, submitted in early 2024, included a new provision. Developers who chose to use external payment links would be required to display a warning to users. A pop-up, Apple designed, Apple mandated. The warning read, "You are about to leave the App Store. Apple is not responsible for the privacy or security of purchases made on the web." A court-ordered freedom, wrapped in a court-approved scare message. Judge Gonzalez Rogers later described Apple's compliance as a calculated move, designed to undermine the spirit of the injunction. She referred the matter for criminal contempt investigation. That investigation is ongoing. The Department of Justice had been watching. In March 2024, the DOJ, joined by 16 state attorneys general, filed a landmark antitrust suit against Apple. The complaint ran 88 pages. It alleged Apple illegally maintained a smartphone monopoly not just through the App Store, but through a systematic pattern of blocking technologies that would reduce iPhone dependency. Cross-platform messaging, cloud gaming, third-party digital wallets, super apps. Each one, the DOJ argued, was suppressed, not because it was unsafe, but because it threatened the ecosystem lock-in that makes switching away from iPhone feel expensive and painful. The DOJ used a specific internal phrase found in Apple communications, moat deepening. That is not a metaphor a compliance team would invent. That is a strategic objective. Apple called the App Store a feature. The DOJ called it a moat. Internal documents used both words. Apple chose which one to say in public. The consumer class action followed. Plaintiffs argued that iPhone buyers, not just developers, were harmed directly. That Apple's App Store policies inflated app prices and suppressed competition, meaning consumers paid more for software than they would have in an open market. The legal theory traces back to a 1992 Supreme Court decision, Illinois BRIC, which governs who can sue for antitrust damages. In 2019, the Supreme Court ruled 5-4 that iPhone users could proceed with their own antitrust claims against Apple. Justice Brett Kavanaugh wrote the majority opinion. The case name, Apple v. Pepper. Plaintiffs, iPhone users. Every one of them. The class action now encompasses hundreds of millions of iPhone users in the United States. The damages model used by plaintiffs' economists estimates that Apple's App Store monopoly inflated app prices by 30%, above what a competitive market would support. 30% of every app purchase, every subscription renewal, every in-app transaction, over a decade. The total damages figure cited in court filings exceeds $1 billion. Some economic models place the realistic figure significantly higher, depending on what conduct the jury credits. Apple disputes every number, but they have not yet been asked to present those disputes to a jury. One number Apple has not disputed: developer revenue share. In 2020, facing antitrust pressure, Apple launched the Small Business Program. Developers earning under $1 million per year would pay a 15% commission instead of 30%. Apple announced it as a gesture of goodwill toward small developers. What the announcement did not mention: developers who cross the $1 million threshold revert to 30% for the entire year retroactively. An app that earns $1.1 million pays 30% on all of it. The structure does not reward growth. It taxes it. Meanwhile, Apple was expanding. In fiscal year 2023, Apple's services division, which includes the App Store, generated $85.2 billion in revenue. It is now Apple's fastest-growing segment and its highest-margin business. Hardware is flattening. Services are climbing. The App Store that Tim Cook called a feature of the iPhone now generates more annual revenue than McDonald's entire global operation. This is not a side effect of Apple's success. According to the DOJ complaint, it is the design. There is a woman named Pepper. She is not a metaphor. Barbara Pepper is the named plaintiff in Apple versus Pepper. the case that reached the Supreme Court. She is an iPhone user from California who alleged she paid inflated prices for apps because Apple eliminated every competing marketplace. She did not work in tech. She was not a developer. She was a consumer who bought a phone and, according to her complaint, paid more than she should have because there was no other choice. The Supreme Court agreed she had the right to make that argument. The case has not reached trial. It has been active for over a decade. Apple is currently worth $3 trillion. The App Store case is still pending. The DOJ suit has no trial date. The criminal contempt referral is unresolved, and the next iPhone ships in September. The device in your pocket may be evidence in a case you didn't know you were part of. This is Redacted Chapter. Subscribe so you don't miss the next one.